Welcome back to Beyond Formation, your legal roadmap for the first year in business and even beyond. In our last episode, we looked at some of the critical legal steps that you must take after forming a new LLC and how to maintain your business entity throughout its legal life. But an LLC filing is just the beginning. The biggest mistake growing businesses make is thinking that their legal work is done once those articles are filed with the Secretary of State. But the truth is, that was the easy part. Your business is scaling and your legal framework must scale with it. So, in this second video in the series, I'm going to show you how to professionalize the documents that are the bedrock of your financial and operational health. Contracts are the primary line of defense, but only if they're structured in a way that actually protects where your business is going and not just where it started. My name is Maritza Shay Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that the legal stuff might come back to bite them. As your business transitions from the startup phase to a mature, growing business, your legal framework, especially your contracts, must evolve in sophistication. Contracts are not merely formalities. It's not just something that, we attorneys put together, as a gotcha to charge billable hours. Contracts are the key to maintaining your business relationships. They document expectations and they're the primary line of defense when things just don't work out as intended. A proactive approach to contract management is essential for sustainable growth. When you think about your business contracts, I want you to focus on these critical areas to professionalize your legal agreements. Let's start with your client agreements, or those standard terms and conditions. The most critical legal shift for a maturing business is moving from just accepting whatever contract your client sends you to proactively presenting your own standard terms. As your business grows, you need to transition from passively agreeing to a client's terms and conditions, which are often negotiated and drafted to favor them, to presenting your own professionally reviewed and regularly updated professional services agreement or standard terms and conditions, or whatever that key document is that you use for your particular products or services. This is especially true if your clients are larger business entities. These guys will often send very generic agreements for vendors like you to sign. Doing so, it saves their in house counsel all kinds of time. They don't have to go and negotiate every single time this big company brings in some sort of a vendor. But these form documents tend to be very one sided, especially when it comes to key issues like protecting your intellectual property. If your client sends you their standard vendor contract, it often says that everything you create belongs to them. But that doesn't work if you're a consultant who provides similar content and similar consulting services to other clients. Standardizing the payment terms. Have you ever received a contract that says your client will pay you 30, 60, or even 90 days after the job is done, and then only if they're satisfied with your work, in their sole discretion, of course? Those are the kind of one sided terms that you shouldn't just be signing automatically. Clearly defining the scope of work. So many contract disputes boil down to this lazy mistake. When we go back and look at the scope of work, oftentimes it doesn't clearly define exactly what done is. And the result is scope creep. Your client is asking for more and more, whether it's more services or more revisions to the project, and suddenly you're putting in way more time and effort than the job you actually priced. Setting consistent limitations on liability. A well drafted contract will limit the extent of your liability in the event of a dispute. But if this portion of the contract is missing or isn't done right because you relied on some cheap internet form document, you might find yourself facing a breach of contract case where your disgruntled client or customer is seeking damages, not just for the value of the contract, but all kinds of tangential claims for lost profits or lost data or the cost of finding a replacement vendor to provide the services at the last minute. Your standard terms should address these issues explicitly. They should include clear warranties and disclaimers and termination clauses just in case the customer client relationship doesn't work out. We always go into these situations with the best of intentions, but good intentions aren't really a legal defense. Now, the other area where you need to professionalize your contracts is going to be any situations involving complex transactions and major strategic moves. Involving legal counsel as early as possible when planning significant, non standard transactions. Your business attorney needs to be there to perform the necessary due diligence, to structure the deal to be tax efficient and legally sound, and strategically position you for negotiations. So, what do I mean when I'm talking about high stakes transactions? I'm talking about any time that you're buying or selling a business, or even just getting a substantial chunk of assets from another business. Anytime you're purchasing or leasing real estate, whenever you're forming a strategic partnership or strategic joint venture with somebody else, and we'll talk about more about that in just a moment, bringing in outside investors, whether it's equity or debt financing, and intellectual property licensing. Whenever you're granting or acquiring rights to use proprietary technology, content, or trademarks, those IP licensing deals are way more complicated than most people think. The complexity of these types of contracts, which often involves multiple parties, sometimes intricate financing, long term obligations, all of this means that the sooner you get your legal team engaged, the better we can prepare for what might be protracted negotiations, the better we can help you identify some of the hidden risk in the deal, and ultimately help you protect your long term interests. Now, let's talk about those strategic partnerships, whether they're joint ventures or collaborations. Anytime you're collaborating with another business for mutual benefit, we want to make sure that that's structured with foresight. So, how are we defining the roles, the responsibilities, and exit strategies? These arrangements are often structured in one of two primary ways. The most common one that I see working with small businesses is more of your contractual joint venture. We put together a partnership that's covered by a comprehensive contract. Each party is still going to be its own independent legal entity. And in some sense, these can be a little bit simpler, and they're often used for short term projects or very well defined scopes of work. The other possibility is to set up a brand new entity, which you might sometimes see called an equity joint venture. So, this is a new separate legal entity, whether it's a new LLC or a new corporation, that both of the parties jointly own and manage. So, your LLC and the other company that you're working with, their LLC, are both going to be members or part owners of this new LLC. For long term, complex partnerships that involve shared investment, separate operations, significant exposure, those are the situations where we might look at actually establishing a separate entity to house this joint venture. This new entity can provide a crucial legal shield, isolating the liabilities of the joint venture from the separate companies, protecting each partner's core assets. For more on this, check out the other video that we've done on holding companies and when they really make sense. There, I dive into using a separate entity to isolate some of the business liabilities from other entities. Regardless of the structure, the agreement must clearly outline governance. So, how are we making decisions? Capital contributions. What is everybody putting into this new partnership? How are we sharing the profits and losses, dispute resolution, and critically, a clear and defined exit strategy. So, what are those buy sell provisions? What does it look like if we liquidate this new project or this new entity, just in case the partnership dissolves? Again, best laid intentions, not a legal defense. An ounce of prevention in contract drafting is worth a pound of cure in litigation. By embedding clear conflict management mechanisms, you significantly reduce the risk of expensive, public, nasty, protracted litigation. We want to ensure that when disagreements arise, and being an attorney, I'll tell you, disagreements arise all the time, there should be a clear, cost effective path to resolution that protects your business. Personally, I like to use a multi tiered approach. In any core business contract that my office puts together, we typically outline how disagreements will be handled in three steps or three phases. The first is initial good faith negotiations. Have the parties just sit down and meet and attempt to resolve the issue directly, put a time frame on it, but let's say, hey, let's just sit down like rational adults and see if we can work this out before we go spend a bunch of time and money with attorneys and try to resolve our issues on our own. If that fails, then the next thing I'll typically put in the contract is mandatory mediation. So, this is where the parties agree to hire a neutral third party mediator to try to facilitate a settlement. In my experience, if everyone is committed to reaching a business resolution and not just trying to stab each other in the back and prove who was wrong and who was the worst person, the mediation can often resolve the vast majority of business disputes confidentially and quickly, which means it also saves you money. As a last resort, then we can look at arbitration or litigation. The truth is that either option is incredibly expensive, it's time consuming, it will distract you from your business, and the truth is no one really wins except the attorneys. We also want to make sure that your key contracts have some key jurisdictional and procedural clauses. So the choice of law provision that almost no one ever looks at, this is the clause that specifies the jurisdiction whose laws will govern how we interpret the contract and how the contract is enforced. All too often, I'll see clients sign a contract that says it's governed by the law of random state X that they're not really in, they're not doing business in, and they don't know what laws are going to apply in that situation. The other one is your jurisdiction or arbitration clause. This determines exactly which forum we're going to go to if there is a dispute. So, if we've gone through negotiations, we've gone through mediation, where do we turn to next? Oftentimes, this is the clause that says the state and federal courts in Columbus, Ohio, or Franklin County, Ohio, shall have exclusive jurisdiction. An arbitration clause is very similar, it just mandates that the process goes through arbitration, which some people argue is faster and cheaper than going through litigation in court. So here you might see any dispute arising under this contract shall be submitted to binding arbitration in accordance with the rules of the American Arbitration Association or some other arbitration body. So we've covered the complexity of standardizing client agreements, structuring those strategic partnerships, and embedding proactive dispute resolution. All of this points to one undeniable truth. Legal diligence is not a one-time event. It's an ongoing strategic process. The moment you stop evolving your legal strategy is the moment you expose your business to unnecessary risk. And this is exactly why I offer an outside general counsel service. If you're ready to move from simply reacting to legal issues to thriving with proactive legal strategy, outside general counsel service is your essential next step after business formation. With a predictable flat monthly fee, you get a dedicated legal partner already familiar with your operations, focusing on these core areas that truly protect your growing business. Risk reduction and compliance. So we regularly review your contracts and business practices to minimize potential pitfalls. Future focused strategy, aligning your legal roadmap with your next 12 months of business goals. What are you trying to accomplish in the next 12 months and what are you most worried about? Okay, great. That tells me what legal issues we need to be focused on for the next 12 months to help you get to where you're trying to go. And last, timely guidance. Proactive support before you sign a major lease, before you onboard a key employee, before you launch a complex joint venture or strategic partnership. Move beyond formation to sustainable growth by building your legal roadmap with me or frankly whoever you know, like, and trust as legal counsel before a legal crisis hits. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you love what you do and want to build something amazing or take amazing to the next level, then let's talk. Check out the link in the description to schedule a consultation to explore how outside general counsel service can assist you. And while you're at it, don't forget to download your post-formation legal checklist. Until next time.